much, Michelle, for being here. We really appreciate it for round two, because the first one was slammed, and so many people had more questions. For those coming in from home, this is going to be videotaped. Thank you so much for joining us, and a lot of people submitted questions ahead of time. So Michelle has a long list, but if you have questions, this is also a great time for you to get those answered. Our next event is going to be September 4th. Bath Housing is going to be here. They'll talk about all of their programs, but specifically Comfortably Home, which does home repairs and things like that. Everything from changing a light bulb to fixing a door. So that is coming up as well. Thank you, Michelle. All you.
Okay. Well, thank you for coming out. My name is Michelle Maynard. I'm an elder law attorney, and I have my own practice in Topsom. Before starting out on my own, I worked for a couple of firms in Falmouth and Portland, and before that I worked for legal services for Maine elders for nearly 10 years. So I really enjoy working with older adults and families to help older adults, and I'm going to just sort of go straight into the questions that were submitted in advance, because there's quite a few of them, and some of them are very good, and I think we'll cover a lot by just going through the questions, but please interrupt if you have follow-up questions or you just have something specific you want to discuss. So the first one has to do with, my mom is starting to forget things and I'm worried about her handling money. What legal stuff should we get figured out now before things get worse? So really, for any adults who have assets, it's a good idea to have some basic estate planning documents in case something happens unexpectedly or suddenly. And so by basic estate planning documents, I'm referring to financial power of attorney, a healthcare advance directive, and some sort of estate plan, either a will or perhaps a revocable living trust. If someone is starting to have difficulty managing finances, then the financial power of attorney becomes even more important. Okay, so when you sign a financial power of attorney, you're delegating your own authority to someone else who can act on your behalf. If you get to the point where you do not have the legal capacity to sign a financial power of attorney, then someone needs to petition the probate court to become your conservator. This should be a last resort. Okay, going to court is very expensive. It's time consuming. In some counties, it can take months to get a court date, and the court stays involved. So even if it finds that, yes, this person needs help, they can no longer manage their own finances, an appropriate person has filed a petition to become the conservator, the court supervises that conservator, and the conservator may need to go back to court to get specific authority to do certain things, like sell the principal's house. And the conservator has to submit annual accountings and reports to the court. So it's burdensome for the conservator, it's expensive, and it's time consuming. So it's much better to have a financial power of attorney where you decide who you would like to act for you, instead of having a judge who has never met you, has no idea what your personal preferences are, make that decision for you. Okay? Any questions about that?
Are there forms just like online that are reliable to do that
No.
yourself? That's what I thought.
No. So for a financial power of attorney, I would never recommend using an online form. When I worked for Maine legal services for Maine elders, I saw so many invalid forms. They didn't comply with Maine law. They were not worth the paper that they were printed on. The only legal form that I will recommend people use is the Maine Hospital Association's Advance Directive form. So that's widely available online. It's often available at your doctor's offices, and that form is fine to use.
The advance directive form
Yes.
is also a financial power of attorney
No.
form? No.
No, they're separate documents. Years ago, they used to have just a general power of attorney that might include both financial and healthcare matters, but that's not the case anymore. You have a separate financial power of attorney than the healthcare advance directive. And the financial power of attorney should always be drafted by a Maine attorney. Yeah. Any questions about that? No, okay, great. So question number 2, my father has early dementia and is getting to the point that someone needs to help him with managing his money. He's missed a couple of bills and he's loaned money to a neighbor. He doesn't want his children getting involved and insists that he is fine. What are our options as he declines further? So it's hard in this situation where someone is trying to retain their autonomy, but really does need some help because there's some diminishment there. And so what I would suggest in that case would be to try to get him to speak to an attorney who could give him his options. And what may be more enticing to him would be to have what's called a springing power of attorney. So there's two options to when a power of attorney takes effect. That can be immediately when the principal signs it. It doesn't mean that they give up their rights to handle their own finances. It just means that their agent, the person that they name in the document, can start acting for them immediately. Or it can be springing, which means it doesn't take effect until a stated condition in the document happens. And that's usually when a doctor determines that someone is incapacitated. So if he wants to try to retain, control a little bit longer, he may feel a little bit better with a springing power of attorney. So if he does get to the point where he really is not capable of making informed financial decisions, then his agents could act on his behalf. And the other thing an attorney would most likely point out to him is that if he doesn't make these choices for himself, someone else will make them for him when he has declined to the point where he can no longer sign legal documents. And again, that's the conservatorship route. So it'd be a probate judge who makes that decision. And usually a judge would appoint someone's children, unless there was a valid reason that they were not an appropriate choice. If they have a lot of debt themselves and they're just not very good at managing money, or there's been a history of conflict between the respondent and that child, then the court may not appoint that person. If there's no one who's appropriate, then DHS becomes the conservator, and no one wants that. It's a state agency that is a huge bureaucracy, not very responsive to the needs of the people that it's serving as conservator for. No one would make that choice if, unless they had no other options, okay? So I would just encourage this person to have their dad meet with an elder attorney and at least get the options and get some information. And again, he'd be the one to make the choice though. You can't force a person to sign a financial power of attorney, okay? Question 3, how can I protect my mom from being taken advantage of financially by my sibling? Especially since she's starting to get a little confused. Again, the financial power of attorney is probably the most effective way to prevent financial exploitation of someone who has some diminishment, okay? What's the difference between having power of attorney and being someone's guardian? Okay, so a guardian makes decisions about someone's person. So medical decisions for them, where they live, who gets access to them, while a conservator has financial decision-making power. But it's the same process. You still have to petition the probate court to become someone's guardian. The court stays involved. The guardian has to ask for specific permission to do certain things, and the guardian has to file annual reports to the court. So again, if there's someone that you feel comfortable making medical decisions for you, or perhaps place them in a long-term care facility if that ever became necessary, much better to sign an advance directive than having to go to court to become guardian for someone. Okay, any questions? I have an adult child with special needs. How do I make sure that they're taken care of if I end up needing long-term care or after I'm gone? So I'd say if you have a child who has either a disability or trouble managing money, or they're just more vulnerable to being financially exploited, you really need to make sure that you have good estate planning documents to protect that child. So there's options if the child is disabled, setting up a trust for their benefit so that they can benefit from an inheritance from your estate, but not lose public benefits that they may rely on, such as maid care or SSI, or even subsidized housing. So you absolutely need to have good estate planning documents in those circumstances. Same with if you have a child who just is not good at managing money, they just blow it. You know, if they get a windfall, it's gone, you know, no time. You might want to trust for that child to sort of protect them from themselves. And again, you need estate planning documents to achieve that. Okay, so next question is, I have some money saved and I'm not sure if I should leave it to my kids outright or set up a trust. What's the difference really? Okay, and I get this question a lot. People are very confused about trust. So a trust is just a legal instrument that is for the benefit of certain people, and there's a trustee who manages the assets in that trust. And there's many different types of trusts, so it really depends on what your objective is. There's a certain type of trust if you just simply want to avoid probate after you die. There's a trust for a disabled person, it's called the Supplemental Needs Trust. And there's trusts that offer creditor protection. So again, if you're concerned about a child of yours having some debt issues and you don't want a creditor to get their inheritance, then you might want to set up a different type of trust for that. So if you don't have a trust, most likely your estate is going to pass either through intestacy, which means you don't have a will or other estate planning documents, or a basic will. And a will takes effect when you pass, but most likely a trust is a standalone document that takes effect when it's signed. Okay, so those are some of the differences between those two. To be a little confusing, you can also have what's called testamentary trust, which are trusts that are established in your will. So they don't take effect until you die, and they're sprung to life through the probate process.
So if you have a trust, does that mean you no longer have access to whatever you put into the trust?
It depends on the type of trust, okay? So in some states where probate is a real headache, like Massachusetts and Florida, everyone has a revocable living trust. And the purpose of that trust, for the most part, is to avoid probate. And with that type of trust, the grantor, the person who creates it, is typically the trustee and the lifetime beneficiary. So it's all about you still. You have full access and control over the assets. If you're creating a trust to try to protect assets from long-term care costs, you wouldn't have control over the assets in that trust.
Would not?
You would not. So it depends on the type of trust. It's very case specific. And it depends on what you were trying to achieve for that trust.
So there's no general.
There's no general
You
trust.
really have to look at the specifics of
Yes.
the situation.
Exactly. Okay. The next question is, my dad has dementia and never made a will. Is there anything my sisters and I should be doing now? So if someone dies without having a will or a living trust, their estate passes by the laws of intestacy. And what the Maine legislature tried to do is think of, in most cases, what would most people want if that were the case? And so it goes to your closest heirs, which is your blood relatives. So your spouse, your children, your grandchildren, your parents if they're still alive, your siblings, and it goes out, through the branches of the family tree. Even though someone has a diagnosis of dementia, that doesn't necessarily mean that they lack the capacity to sign a will, okay? So legal capacity is very case specific, and it depends on what document the person is signing. So for a will, it's the lowest amount of capacity required for a legal document. And the bar, I have to say, is quite low. You do not have to have a lot of capacity to be able to sign a will. Generally, you have to know the natural objects of your bounty, so who are your heirs, who are your relatives, and have a general idea of what you have for assets. And again, you don't need to know that you have $52,000 in this money market account. You just have to have a very broad understanding of what you own. So don't think that the diagnosis precludes someone from necessarily signing a document, okay? And so an attorney would make that determination most likely if someone had the requisite capacity to sign. And in really close calls, sometimes myself and other elder law attorneys will get a doctor's opinion. If we really we're having a hard time, if we just want some documentation, we might have a doctor weigh in on that decision as well, okay? So I would still recommend that you talk to your parent and see if they would be willing to consult with an attorney and see if they could sign legal documents. Even though there's a default, if they died without a will, it's generally better for their wishes to be known, and they can name who they want to be personal representative or executor, so the person who would be in charge of probating or handling their estate. And again, there may be some surprises when they talk to an attorney and they're talking about what they would actually like to have happen to their estate after they're gone. It's not always equal shares to my kids, or everything to my spouse first, and then equal shares to my kids. So encourage that parent to speak to an attorney. Next question. My dad has a camp up north that he barely uses. Should we sell it, give it to someone, or hold on to it? What would be the best move when it comes to main care and taxes? So this is a quite complicated scenario, and it depends on a lot of different factors. If it's sold and long-term care is an issue, you need to make sure that it's sold for fair market value. So you can't sell it to your child or your grandchild for $1 or for $20,000 when it's really worth $200,000. That's going to affect your main care eligibility in the future. If you hold on to property and it passes either by intestacy or according to your will, the person who receives it gets a step up in cost basis. So that can be very advantageous from a tax perspective, especially in Maine, because real estate has appreciated in value so much in recent years.
I'm sorry, what did you just mean about step up in cost basis?
Yeah, I'm gonna explain that.
Okay.
So when you make a gift during your lifetime, so if you want to gift real estate to your child, the cost basis that you have in the property, which is what you paid for it, and your capital improvements gets transferred to your child. So if they later sell it, they could be subject to capital gains tax on the difference between their sales price and the cost basis, okay? If they inherit that property from you instead, so you hold on to it until you die and then it passes according to your will to your child, they get a step up in cost basis to the fair market value of the property as of the date that you died. So all that market appreciation gets passed on to them. So when they sell the property, the amount that's subject to capital gains tax is much smaller, okay? This may not be important if they decide to use that property as their primary residence. If not, if they just decide to have it as an investment property or as a second home, then capital gains becomes a huge consideration for people, okay? So it depends on so many factors, but that's a good question to talk to an attorney about. So those are sort of the estate planning, guardianship, conservatorship questions that I had. Does anyone have any other questions sort of in that vein?
What is a living trust?
Yeah. So a living trust is a will alternative, okay? And so some people in Maine have it, but it's not as common. In states where probate is a nightmare and you don't want to have to deal with probate, like Massachusetts, everyone has a revocable living trust. And so it's a trust that you create during your lifetime and you transfer your assets into that trust.
Oh.
All of them, except for qualified retirement accounts, okay? Because the trust can't own those. But you transfer your house, sometimes you transfer your vehicle, your bank accounts, most of your assets into that trust. And the purpose is, when you pass, there's little to nothing owned in your individual name, so then your estate doesn't have to go through probate, okay? You are the trustee of that trust initially, so you manage the trust, and you're the lifetime beneficiary. So it's all for you. So there's no loss of control over the assets. The trust will even use your own social security number, okay? So it's often used to avoid probate, and in like limited circumstances, it can be used if you just wanna keep your estate plan private. So in Maine, when you probate a will, the will is available online for the public to see. So if you had anything sensitive in that document, you know, I'm disinheriting my child because he's a drug addict, or he's just been brought into me and I don't want him to receive anything. If you don't want the world to know that, you might have a trust instead, because a trust is only available to the beneficiaries.
But you can just outline who gets what in the trust.
Yes, the trust provides for what happens to the assets after you're gone. So it's a way to manage assets during your lifetime and after you're gone, because you would name remainder beneficiaries in the trust document itself. Okay, so those are the two reasons people usually have a living trust: avoid probate and keep your estate plan private. Another one is if you have some relative that is just a big troublemaker. You just worry that they're gonna contest some aspect of your will, even though they may not have a legitimate reason to do that. They're just trouble, and so you want to, you don't want to give them the opportunity to do that. So again, with a trust, you avoid going to court, and most likely that person who you're concerned about would never be entitled to even see the trust document itself. So again, it's a way to, in very limited circumstances, to avoid someone contesting your estate plan because they're not going to know about it. Okay, any questions about the living trust? I get that a lot in my practice. Everyone thinks they need a living trust because they've heard Susie Orman or some other financial advisor talk about it.
Yeah, I have a question. You said everything except the money market accounts goes into the living trust? Your bank account, car, home, what did I miss?
Everything except a retirement account.
Like a
So-
401k?
Yes, your 401k, your IRA, they're not gonna go into the living trust. You should have named beneficiaries on those accounts, so they pass outside of probate anyway.
Okay, so if everything's in the trust, including your bank account, how do you stay involved with it? How do you pay your bills with it?
You're the trustee, so you would open up new accounts in the name of the trust,
Okay,
and as trustee, you have access to those accounts. So if you're paying your mortgage, you're still able to do that.
okay,
You still have full access and control over the assets.
okay.
Yeah, so the living trust is the best way to think about it is that it's your alter ego, okay? So it's all about you, you created it, it's for you, you manage it. But you do have to retitle assets if you want to avoid probate.
Is there an ongoing cost for that, or is that a one-time thing where you set it up and
Yeah, most of the cost is incurred up front to set that up because it's a more complicated document than a basic will. And then some people think that there's no back-end costs involved, and that's not accurate. So when the grantor passes and things go to the remainder beneficiaries, there is some administration that needs to be done. It's not usually as expensive as probating a will, but I think that the costs almost even out in the long run. So that's another reason some people don't favor the living trust, is because it costs more to set up than your will. And people think, well, no, my kids, they'll just receive a little bit less when they probate my estate and get things that way.
If you have bank accounts with beneficiaries on them, why would they need to go into the trust?
They wouldn't. You just wanna make sure that those beneficiaries are alive when you pass, otherwise that would become part of your estate. So,
And if you have multiple children and one of your children that happens to predecease you, does the money go to their children?
it's up to you. So you get to make
Yeah,
that choice in the
designate.
trust document. itself.
And what does the living trust cost?
Well, and again, it's hard to say because it depends on what you have for assets and how much is
Just a
gonna
range.
be transferred. I would say, it's a couple thousand,
Okay,
so it is more than a basic will.
thank you.
And the big thing is that you just need to make sure that the trust is properly funded, because I have seen so many people come in for me to review their estate plan. They have a great trust document. They have not moved their assets into the trust, so if they had passed, it was all for nothing. Their estate would still need to be probated. So, and I will say, in Maine, probate is not a terrible process, most of the time. So if you have an original will and there's no one contesting any aspect of your estate, they're not saying, oh, the person named as personal representative in the will shouldn't be appointed, or this person lacked capacity when they signed the will. If there's nothing like that, you can do informal probate, and there's no court hearing. It's the register of probate that actually appoints the personal representative, and it's a pretty simple process. It still takes some time. It takes at least 9 months, closer to a year, but a lot of that is inactive time where not much is really happening. So in Maine, probate is not an awful situation.
Is there a minimum amount that,
For an estate to go through probate?
yeah.
Yes. So if the estate owns real estate that requires a legal transfer of title, no matter the value of that property, probate is necessary. And if the other assets exceed $51,000, probate is necessary. If it's $51,000 or less, then you can use what's called a small estate affidavit, and that's very simple. So a lot of people do have the misconception that if you have a will, probate's not necessary. That is not the case. It depends on what the estate owns when you die. Okay. The will just makes clear what your wishes are regarding those assets and who you want to serve as personal representative. The will itself does not necessarily avoid probate.
So if you have a trust and you have a bank account, key bank, and then like the credit union, you have to go to all these institutions and
Yes.
resubmit.
You retitle the accounts.
Retitle.
Yep.
And real estate too?
Yes. So if you have your home, if you have a summer camp, most likely you would wanna retitle those into the name of technically it's the trustee who owns the assets, but yes, you'd want new deeds to do that. Okay.
So if you have assets that you want to try to insure goes to a child, daughter, son, with minimum taxes and legal hassles, so to speak, is there a particular type of trust that you would recommend for that purpose? Or does that really depend on the
Well,
circumstances?
it depends if you still want access and control of the assets during your lifetime.
Let's say yes.
Okay, then the living trust most likely would
The
be
living
what you
trust?
would want, yes. A living trust does not offer any asset protection for long-term care though. So again, you've gotta think about what is your objective. Your objective is to avoid probate and make it easy on your kids to receive those assets after you're gone. The living trust might be a good option for you. If you're worried about nursing home costs, a living trust is not gonna help you out at all. Because you still have full control over the assets in the living trust. So you haven't achieved any asset protection from long-term care costs.
Okay, so if you end up having to go to a nursing home, you have to make those assets available to pay for those nursing.
Yes. So that is why you need to think
Or
carefully about what you
Whether it's in a
want.
trust for your daughter or child or not.
Again, if you were concerned about long-term care expenses and protecting assets from being used to pay for your long-term care, you would have a different type of trust.
Other than a living trust.
Correct. Okay, and we'll talk about that in a little bit, okay? So, So we're starting to get into the main care questions, and that's where the bulk of the advanced questions, what they focused on. So, first one is, how far back does main care look at your money and stuff? What are they actually looking for? So currently when you submit a long-term care, main care application for either nursing home benefits, assisted living benefits, or nursing home level benefits received at home, DHS, which is the agency that reviews these applications, goes back 5 years from that date of application, and they review your financial records for those previous 5 years. And what they're looking for is to see, have you disclosed all of your assets? Did you tell us about everything that you own? And 2, they're looking to see if you've made gifts. So if you've gifted things to your kids or your grandkids, that could harm your eligibility, okay? So 5-year look back currently, and that's the point of the look back, is they're looking to make sure you disclosed everything and that you didn't try to impoverish yourself to get on this means tested benefit. The next question is, what if my spouse and I don't end up needing nursing home care at the same time? Can one of us stay home while the other one goes into long-term care and get on main care? Absolutely, and that's very common. In fact, it's much easier to gain main care eligibility if you have a spouse and they're at home. So, if it's residential care or assisted living, they don't look at your spouse's assets, the spouse at home that's healthier. So that's a great planning opportunity because you can shift assets into the name of the healthy spouse and qualify the person in the assisted living facility for main care. Okay.
But you got a 5-year look back.
Spouses can always transfer assets to each other with no penalty. That's always allowed. Even right before you submit a main care application, or after you submit the main care application, that's okay. So yes, it's absolutely possible for one spouse to be on main care and the other spouse to be at home.
So in terms of finances in that situation, said person going into long-term care is receiving Social Security, is their Social Security is attached to that main care to cover the costs of the long-term hopefully?
Yes.
But not the spouse's, is
Correct.
not attached? Right?
Yes.
Okay.
So if you get on main care for long-term care, in most cases, your income, your Social Security, your pension, is going to be used to pay what's called your cost of care at that facility. If you have a spouse at home and they have very low income, it is possible that some of the institutionalized spouse's income can go to the spouse at home, okay? And again, it depends on what level of care you're at, if it's residential care or nursing home, but that is an option. But the spouse at home, their income is never used to pay that cost of care. Any questions about that? My daughter and son-in-law are buying a house. I'd love to help them out with some money, but I'm worried it might mess things up if I need main care down the road. Absolutely, you should be concerned about that because that would be considered a gift. So the only exceptions for making gifts during that 5-year look-back period are gifts to your spouse, gifts to your disabled child, or gifts to a trust for a disabled person. Those are allowed. Otherwise, you would be penalized on making a gift to your child, your grandchild. And when I say penalized, what I mean is you're gonna be kept off of main care for a certain length of time, and it depends on how much you gave away, okay? So the current divisor that the Department of Health and Human Services uses is $11,363. So what they do is they add up all the gifts that you made during that 5-year look-back period, divide that sum by $11,363, and that calculation equals a penalty period. How many months of ineligibility are you going to face? So the more you gave away, the longer the penalty period, where you're not gonna get main care, so you have to be privately paying at that facility. Okay?
On the other end of it, I don't have any documents, so all I was just hearsay. but I had I knew somebody who had to buy family house back from Medicaid,
Okay,
because apparently they had owned the house, gotten Medicaid help, and then Medicaid, after they died, Medicaid came back to collect the bill.
yes, so you're talking about estate recovery. That's once you're on main care, okay?
Well, once you're there, yeah.
Yes, once you're on main care, there's estate recovery for nursing home benefits and at-home nursing home benefits, okay? But if you made gifts during that 5-year look-back period, and they're not to your spouse, your disabled child, or a trust for a disabled person, you're gonna be kept off of main care for a certain
Okay,
length of
that's the
time.
beginning of Medicare.
That's at the beginning, yes.
I'm
Yes, at the end, there could be an estate recovery claim if the main care recipient still had assets in their name. So if they still own their home, let's say,
yeah,
that's usually the
that's the situation.
asset. So if they're a single person, they own their home, they get on nursing home, main care, then yes, after they pass, the state wants to get reimbursed for those main care benefits. And the heirs, or their devisees, depending on what they have for an estate plan, but, they either have to figure out how to pay the state back, or the state can force the sale of the house, and they will get paid that way.
You weren't happy.
Main care is very expensive, and, it's the taxpayers who pay for,
Yeah,
people
well,
in these long-term care facilities, so if there's a way to get paid back, the state wants to pursue that. So it goes both ways, I see both sides of it. So yes, helping your daughter, purchase a home could absolutely affect your eligibility for main care if you need to apply within 5 years, or if your spouse has to apply for 5 years. So, if husband makes a gift, to child, 3 years later, wife needs to go into a nursing home, wife is gonna be penalized for husband's gift, okay? So, something to keep in mind. Just like if you wanted to help a grandchild out with college costs, it's a very legitimate thing to want to do. Main care doesn't care about that. They just see it as a way of you, impoverishing yourself by giving away what you own so you can qualify for this benefit, okay?
So, like with my mother, she gifted for a few years to her children. And then she looked like she was gonna be living. I mean, I'm sure they looked at her assets, and so they stopped the gifting. But if it's before the 5 years,
It's fine,
it's fine. So if you do it earlier,
yes.
you just don't know.
You don't know because the look-back period could be extended. So it used to be 3 years,
Right.
and then more and more people started using this benefit. So they extended it to 5 years. I would not be surprised if they extend it once again at some point because long-term care facilities are full. So you don't know
Yeah.
if that could happen, so. Right now it's 5 years, I don't think there's any pending legislation to extend it, but it's always tossed around, so. My parents want to sell their house to me and, then they would rent it from me. They think it would make things easier as they get older. Is this a good idea? It could be. The sale would have to be for fair market value, otherwise your parents could be penalized for making that partial gift. But I have had clients do this, and the parents can pay fair market rent and not have that be considered additional gifting to the child. So again, something that you need to consult an attorney about for sure, an attorney who practices main care law, but it's a possibility. Okay. Someone asked if I move my savings into an irrevocable trust now, will that help me qualify for main care in 5 years? Potentially. So this is a different type of trust that is set up for long-term care asset protection. With this type of trust, you don't have any control over the assets that you've given away. So the most common scenario for this is a second piece of real estate, you know, a vacation home, a family camp that you really want to keep in the family. But if you do that, you are not the trustee of that trust and you cannot be a beneficiary of the trust. So once it's done, you can't take it back. So it's just something you need to think very, very carefully about. And you need to make sure that you've retained sufficient assets in your own name. So if the worst case scenario happened, you had a stroke the next month and needed nursing home care, that you're able to pay for that care. Because you'd be penalized on making the gift to the trust. So if it's real estate, it's gonna be the fair market value as of the day that you signed the deed. So that could be a lot of money and you could be kept off of main care for years. But yes, that is a planning technique, but again, you need to talk to an elder law attorney who does these types of trusts frequently. If my parents run out of money, can I be on the hook for their nursing home bills? Not generally. The only situation where that could potentially occur is if you sign the contract and make yourself personally liable for the debt, or if you're acting as agent for your parent and you're not taking the steps to apply for main care if they do not have sufficient funds to pay privately. As agent, you have an obligation to find a payment source for your parent or the principal who needs long-term care. So in most cases, no, children are not liable for their.
An agent,
If you're acting as agent for someone and they cannot afford to be privately paying at a facility, you are obligated to apply for main care for them.
oh, okay.
Yeah, you've got to find a payment source for their long-term care. Let's see. People talk about spending down to get on main care, but what kind of stuff can you actually spend money on? What should we avoid? We were thinking about purchasing a car and putting a new roof on the house since it's almost that time anyway. So if you're not close to needing long-term care, you should be spending your assets as you see fit. So on yourself. That doesn't necessarily mean giving it away to family members. But if you want or need a new vehicle, you should purchase that for yourself. That's fine. When you spend money for yourself or for your spouse, you're not going to be penalized for that if one of you needs to apply for main care in the future. And it doesn't have to be even on necessities. If you want to take a very nice vacation, or if you want to go to the casino and blow a bunch of money, DHS doesn't care about that. So it's just when you give money to someone else, that's where the rub comes in. So you can spend your money, that's absolutely fine. My dad gave me a big chunk of money recently. If he ends up needing main care in a few years, could that gift come back to bite us? Yes. So again, it's a 5-year look back period. They're not gonna go after the son, or actually it could be a daughter, that received the gift. They're gonna penalize dad for making the gift. If I move in with my parents to help take care of them, could that affect their main care or other benefits? Are there any advantages to doing this? Yes, that can actually be quite advantageous. So if you move in with your parents and it's your primary residence, and you do that in order to help keep them out of a long-term care facility and a doctor is willing to verify that, and you do that for 2 years before they do end up in a long-term care facility, you can potentially, your parents can gift you their house without penalty.
If a daughter, for example, does that, her and her parents have to have the same address, or could it be like a duplex where parents live on an apartment on one side and the daughter on the other side?
Yeah, it gets really complicated with sort of multi-family arrangements. This is talking about you move into your parents' house not a separate unit on the property or a duplex, then it's potential that you could, again, transfer the house to that caregiver child and not be penalized for that. But of course, again, can't stress this enough, you need to talk to an attorney who can make sure that you have the correct documentation to do all of this. Okay, but yes, I've done that for several clients and it has worked out quite well. What's the difference between assisted living and nursing home when it comes to main care? Do they cover both? Yes, main care does cover both. You need a much higher level of need, of care needs to be in a nursing home than assisted living. I tell people that on a bad day, I could go into assisted living. I forget to take one of my medications. Oh, I need help with medication management. So it doesn't take much to get into assisted living. Nursing home, you need to require extensive assistance with 3 activities of daily living. There are different eligibility requirements for main care based on the level of care that you need. It's most evident when you have a spouse. So again, if you are in assisted living, your spouse is at home, DHS doesn't care about your spouse's assets. They can have unlimited assets and you could still qualify for main care. If you're in a nursing home and your spouse is at home, that spouse at home is now subject to an asset limit as well. And it's roughly $158,000, not including the primary residence. So you've got to do, if someone has significant assets, you need to do a little bit more manipulation of those assets for nursing home eligibility. There's also a difference when it comes to estate recovery. So estate recovery applies only to nursing home benefits and benefits received at home that are nursing home level. It does not apply to assisted living anymore. So that's a huge difference. And that change happened a few years ago. My parents and I share a bank account. When they apply for main care, will that money count as theirs, mine, or both? DHS does not like joint accounts, no surprise there. They'll make you take your name off your parents' bank account because it shouldn't be on there anyway. And yes, most likely if your parent is the one that deposited all the money, then that account is theirs. They're not gonna split it between half is yours and half is your parents'. If I pay out of pocket for a home caregiver for my parent, is there any way for me to get reimbursed later through main care or something else? If you're paying for home care for your parent, then yes, you should get reimbursed for that. That's their expense, and they could reimburse you. And again, if you have the right documentation, it wouldn't be considered them making a gift to you. Okay. Can my parents pay for their own funerals in advance without messing up their main care eligibility? Yes, and the amount that you can pay for a mortuary trust, which is a prepaid funeral or burial contract, is now up to $18,000. So that's a very good way to perhaps spend down some money if you're looking at a main care application in the near future. My granddaughter needs a new car and I want to help her out. Could that mess up my chances of getting main care? Yes, absolutely. You need to go 5 years before making that gift. And you also don't want to be on the loan. That's also not a good idea. So yes, again, you can make gifts. You just need to be aware that there's consequences to doing that. And a lot of people get confused between the annual gift exclusion, which is an IRS rule that says now you can give up to $19,000 per year per person and not have to file a gift tax return, and it doesn't reduce your lifetime ability to make gifts. That has nothing to do with the main care rules. Under the main care rules, gifts of more than $500 per calendar quarter are subject to be penalized, unless it's a gift to your spouse, your disabled child, or a trust for a disabled person. So those rules are just completely different. They have nothing to do with each other. So please don't think that I can give $19,000 to each of my children and my grandchildren, and that's gonna be okay for main care. It's not. Okay.
A while ago in the conversation, you said if a spouse couple lived together, and the husband gave money to one of the grandchildren, and the wife and him were still living together. When she has to go into nursing home or health care, why is the couple penalized for that they gave the grandkid? Because it was the spouse that gave it to him, and you said spouses were exempt from that.
Spouses can gift to each other,
Okay,
but if husband makes a gift to a grandchild and wife needs nursing home care within a year of that gift, wife is gonna be penalized for the gift husband made because they're considered a unit.
Maycare doesn't lose. Well,
When you say main care, does that include home care?
It,
So it's nursing home,
it includes
assisted
the
living?
waiver program, which
And then
is
if you-
nursing home level benefits received at home.
So any type of assistance, I'm thinking main care, I'm thinking of nursing home and assisted living, but it's also including your assistance at home, is that correct?
Under the waiver program, yes.
And doctor's bills.
Not necessarily. So, main care is a big umbrella. There's many different programs under that umbrella. There's community main care, which is basically health insurance for people. So I think that's what you mean when you say doctor's bills.
Yeah.
Okay. So I'm talking about long-term care, which is nursing home, assisted living, it's called residential care under the main care rules. And then the waiver program, which is if you medically qualify to be in a nursing home, but you want to stay at home and receive services. Those are the 3 long-term care programs that I'm referring to. Okay. So I think I get through all the questions, and I think we're out of time. So unless there's something else that I can,
Does Maine have community Medicaid?
yes, it's called community main care.
Okay.
Yeah.
And what's the look back, is it 5 years for that?
There's no look back for the community main care program. So again, the rules are completely different.
But what does that cover?
That's health insurance. Yeah.
That's what
So if my husband goes into long-term care, we have assets, he has some under his name,
Right.
I have some under mine. What happens? Do they
Right.
go,
For him to be eligible, he's gonna transfer assets into your name. And if he's not able to do that himself, which most likely he wouldn't be, it'd
there's
be
no time
his
limit?
agent,
Right,
under his financial power of attorney, would be
Okay.
transferring assets to you.
so, and that's not penalized or?
You don't have to worry about the 5-year look-back period for transfers between spouses.
Okay,